The first reaction of Vibhishana was, he asks, O Rama, you are black in complexion. I know that you are the personification of justice. Therefore, I have a doubt whether justice tempered with mercy will be black in complexion. So, for a man to understand what is the dharmic way of life, our Shastras advocated 14 branches of learning. These 14 branches of learning comprised of 4 Vedas, Shadangas, 6 Angas, and 4 Upa Angas. Kautilya also talks about forensic evidence for establishing the cause of death. Just see how he deals with forensic evidence. He says, if a person has been strangulated to death, urine and fecus would have been thrown out of the body. This is true.
A very good afternoon to all of you. My name is Karthike Yadav and I welcome you all on behalf of Yuva. It is my immense privilege to announce that today we have amongst us Honorable Justice V. Rama Subramanian as our guest speaker of the session. Honorable Lordship has served as former judge of Supreme Court of India and Chief Justice of Himachal Pradesh High Court. Justice V. Rama Subramanian completed his LLB from Madras Law College and joined the bar in 1983. Thereon being elevated to the bench, he practiced before a variety of judicial forum for a period spanning more than 2 decades, including Madras High Court, various tribunals, city and small causes court, consumer forums, and many more forums in the state and also at the center. Going ahead, he was appointed as an additional judge of the Madras High Court in July 2006, whereon he went out to become a permanent judge in November 2009. In June 2019, he took charge as the Chief Justice of Himachal Pradesh High Court. Continuing his meritorious rise, the Lordship was appointed as a judge in the Supreme Court in September 2019. Lordship, we are truly honored to have you amongst us. It gives us immense pleasure to have such a brilliant legal mind to grace this session.
Let me start with a very interesting thing. I happen to write a book in Tamil on the principles of law and justice in the Tamil version of the Ramayana. How many of you know why lawyers wear black coats? But actually, the practice of lawyers wearing black coats is traceable to the 17th century England, where the law lords and others went to the funeral of the queen with a black coat. I do not know what the funeral of the queen has to do with law, but ever since then, the Englishmen thought the lawyers should wear black coats and black gown and also wig on the head, so that they are not identified in public after they come out of the court. But there is something very interesting. This practice, which started in England in 17th century, can be traced to something in the Tamil version of the Ramayana written in the 8th century. That was 1200 years ago. There is a particular scene in the Tamil version of the Ramayana where Vibhishana offers to surrender as a refuge to Lord Ram. The moment Vibhishana saw Lord Ram, he was perplexed because Lord Ram was black in complexion. He was not a fair-skinned person. The first reaction of Vibhishana was, he asks, O Rama, you are black in complexion. I know that you are the personification of justice. Therefore, I have a doubt whether justice tempered with mercy will be black in complexion. Vibhishana uses the expression justice tempered with mercy. This phrase, justice tempered with mercy, is something that our courts have borrowed from the Englishmen, from the Anglo-Saxon jurisprudence in less than 200 years, but more than 1200 years ago, our people had conceived that justice tempered with mercy could be black in complexion. Therefore, I wrote in my book that the lawyers started wearing black coats as an indication that they are supposed to render justice tempered with mercy. So, there are a lot of traces of modern jurisprudence in our literature. The most fundamental thing that we are supposed to know is, all of you know that Indian culture set up 4 goals of human life. These 4 goals of human life were what were called Purusharthas, namely Dharma, Artha, Kama, and Moksha. Right? A man is supposed to lead the right way of life, a dharmic way of life. Indians never wanted everybody to renounce the world, renounce the pleasures of this world in order to gain a place in the other world. Our ancestors taught us that you lead the right way of life, a dharmic way of life. By leading a dharmic way of life, you earn wealth, artha. Through the wealth so earned in a dharmic way, you enjoy kama, the pleasures of this world, and thereafter, at a particular point of time in life, renounce everything and seek moksha, namely the liberation. So these 4 goals were set by our Shastras for human beings to attain. How do we attain these Purusharthas, Dharma, Artha, Kama, and Moksha? If we have to attain these 4 goals, you must first know what is Dharma. Unless you know what is Dharma, it is not possible for you to lead a dharmic way of life. Therefore, our Shastras prescribed 14 branches of learning. These 14 branches of learning were called Chaturdasa Vidya. Chaturdasa is 14, correct? Vidya is knowledge. In order for a man to understand what is Dharma, what is the right way of life, 14 branches of learning were prescribed by our Shastras. What are those 14 branches of learning? This 14 branches of learning comprised of 3 things, namely Chaturvedas. Rig, Yajur, Sama, Atharvana Vedas. Then what is called Shadangas. What are these Shadangas? 6 Angas. What are they? Siksha, Vyakarana, Nirukta, Jyotisha, and Kalpa. So 4 Vedas, Rig, Yajur, Sama, Atharvana. Then 6 Angas, namely Siksha, Vyakarana, Chandas, Nirukta, and Jyotisha, and Kalpa. And 4 Upa Angas called Mimamsa, Nyaya, Puranas, and Dharma Shastras. So for a man to understand what is the dharmic way of life, our Shastras advocated 14 branches of learning. These 14 branches of learning comprised of 4 Vedas, Shadangas, 6 Angas, and 4 Upa Angas. You find that Dharma Shastras constituted the 14th branch of learning. So this is how, we talk about what this Dharma Shastra, we must know how this Dharma Shastras came, why these Dharma Shastras came. Dharma Shastras constituted one of the 14 branches of learning, Chaturdasa Vidya. And this Dharma Shastra, but you must remember, for all the 14 branches of learning, the foundation was found in the Vedas. The word Veda itself has its root in the word vid, to know. Therefore, the foundation for all the 14 branches of learning were the Vedas. So, what are the sources of all learning? What are the sources of the law in this country in ancient time? Suppose today, if you ask a student of law, what are the sources of law, various laws that govern all of us? We will say first you have the Constitution. The second source of law is the laws enacted by the Parliament and the state legislatures on the basis of the power given by the power given under the Constitution. Then the third source of law are the rules or executive instructions issued by the government in exercise of the power conferred by acts of parliament or acts of legislature. The fourth source of law is the interpretation given to these laws by the courts. So today, in modern day jurisprudence, you formulate four sources of law, namely the Constitution, the acts of state legislatures, the rules issued by the executive, and the interpretation of law given by the courts. These are the four sources of law in modern day. So what were the sources of law in ancient times? I have told you about these 14 branches of learning, of which Dharma Shastras constitute one. So what are the sources of learning? There is a shloka in the Manusmriti which says, Veda Akhila Dharma Moolam Smriti Silecha Tadvidam Acharas Chaiva Sadhunam Atmanas Tushtirevacha. Look at the source of law as enumerated by Manu. Veda Akhila Moolam Dharma Shastram. Vedas constitute the first, the original source of all laws. Veda Akhila Dharma Moolam. What is the second source of law? Smriti Silecha Tadvidam. These Dharma Shastras have yet another name, and the name for Dharma Shastras is Smriti. Smriti is what is recited, what is repeated. Shruti is what is heard. Smriti is what is remembered by recitation. So these Dharma Shastras, which are called Smritis, they constitute the second source of law according to this shloka. Veda Akhila Dharma Moolam Smriti Silecha Tadvidam. The third source of law is Acharas Chaiva Sadhunam. Sadhus, people who are very learned and the people who are noble. Sadhu means not merely a person who is learned, but a person who is very noble. Because a man may be a very learned man and yet be a crook. He will never be a sadhu, at least sadhus of those days, not sadhus of the modern days. So, Acharas Chaiva Sadhunam, the code of conduct observed by sadhus, men who are learned and noble, This constituted the third source of law. And the fourth source of law is something very, very interesting. What is that? Atmanas tushtirevacha. A man's own conscience constitutes the fourth source of law. There is no other culture, there is no other civilization in the world which says that a person's own conscience may constitute one of the sources of law. Because you can dupe anybody else but not your own conscience, because if you have a conscience, you know whether what you have done is right or wrong. Therefore, Manu traces these 3-4 Vedam, Dharma Shastras, then Sadhu's conduct, and one's own conscience as the sources of law. Now, as I told you, the Dharma Shastras have got another name called Smriti. Smriti is what is remembered, and Vismriti is insanity. If you do not remember what is right, what results is insanity, Vismriti. Therefore, what great rishis did according to the time at which they lived was, there were 18 rishis, sages of this country who codified the Dharma Shastras or the Smritis. 18 sages, 18 rishis who lived at different points of time codified these Smritis, Dharma Shastras, according to the time at which they lived. Who are those 18 rishis, 18 sages? Manu, Parasara, Yagyavalkya, Gautama, Harita, Yama, Vishnu, Shankha, Likita, Brihaspati, Daksha, Angirasa, Prachetas, Samvarta, Achanas, Atri, Apastamba, and Satatapa. These are the 18 rishis who codified the Smritis, Dharma Shastras. So what happened was, whatever Smriti Dharma Shastra was codified by Manu became Manusmriti. Whatever Dharma Shastra or Smriti was codified by Yagyavalkya, it became Yagyavalkya Smriti. Whatever was codified by Parasara became Parasara Smriti. Today, in the in the United States of America, there are several enactments passed at the instance of individuals, private members' bills, what we call here as private members' bills. We don't have the practice of naming the act after the person who brought the bill. But in America, they have the practice of calling the very enactment after the person who proposed that enactment. McCarthy Act, something like that. This practice, which is prevalent in today's America, was prevalent thousands of years ago by calling the Smritis codified by Manu as Manusmriti, that codified by Yagyavalkya as Yagyavalkya Smriti, the one by Parasara as Parasara Smriti. Therefore, private members' bills, something like that, was prevalent thousands of years ago. So 18 sages, Manu, Yagyavalkya, Parasara, Gautama, Harita, Pracheta, Sangirasa, etc., codified the Dharma Shastras or the Smritis, and these became a compilation of Dharma Shastras, the code of conduct for human beings to follow. Apart from these 18 Smritis, Dharma Shastras, there were also something called Upasmritis. There were 18 subsidiary Smritis called Upasmritis. In fact, by custom, people have included the Bhagavad Gita as one of the Upasmritis. I am just giving you a broad introduction of what is Dharma Shastras. Otherwise, you can't simply be repeating what is Smriti, what is Dharma Shastra without understanding all that. Then our ancestors also found out that it was possible for a conflict of opinion between one Smriti and another Smriti. For instance, Manusmriti may contain a particular prescription. Yajnavalkya Smriti may contain another prescription which may run contrary to what is prescribed by Manu. It is not as though all these 18 Smritis speak the same language and contain the same content. Therefore, our ancestors developed, today from Articles 245 to 254 of the Constitution, you talk about conflict of laws. Suppose the Parliament has enacted a law and the state legislature has enacted a law and they are in conflict with each other. Which is the law that will prevail? This is called in the constitutional jurisprudence repugnancy, conflict of law. This is not something that has come up in 100 years or 200 years. Thousands of years ago, our ancestors have contemplated that there could be conflict of laws, that there could be repugnancy. Then how do you resolve these repugnancy? How do we resolve these conflicts? Our ancestors developed what is called Dharma Shastra Nibandhanas. Dharma Shastra Nibandhanas are a set of rules created to resolve the conflict between two sets of Dharma Shastras. So whatever we learn today has a trace in our ancestral jurisprudence. Manu talks about 18 different types of cases that could come up before courts. What are those 18 different types of cases that could come up before court according to Manu? Payment of debts. Number 2, deposit and pledge. Number 3, sale without ownership. Number 4, concerns among partners. Number 5, resumption of gifts. Number 6, non-payment of wages to workers. Number 7, non-performance of agreements. Number 8, rescission of sale and purchase contracts. Number 9, disputes between the owner and servants. Number 10, disputes regarding boundaries of properties. Number 11, assault. Number 12, defamation. Number 13, theft. Number 14, robbery and violence. Number 15, adultery. Number 16, duties of man and wife. Number 17, partition of inheritance. And number 18, gambling and betting. Manu says these are the 18 different types of disputes that come up before court. Today, people who are familiar with courts know that when a civil suit is filed, the person filing the civil suit is called the plaintiff. The claim that he files is called the plaint. The opposite party is called the defendant. The reply filed by the defendant is called the written statement. So we have different terminology developed on the basis of our Anglo-Saxon jurisprudence, which follows the Latin expressions. Now look at this very interesting terminology used by Manu. Manu says, according to Manu, a plaint presented in a civil suit is called Bhasha or Pratigya or Paksha. The plaintiff is called Arthi or Avedaviya or Abhiyokta. Then the defendant was called by Manu as Pratyarthi. Interestingly, Manu says a defendant in a civil suit can set up one of the 4 defenses mentioned by him. What are the 4 defenses? He says, number 1, Sampratipatti or admission of claim. Today in the Civil Procedure Code, you have a particular provision called Order 12 Rule 6. Under Order 12 Rule 6, if a defendant admits the claim of the plaintiff, the court can straightaway pass a judgment without taking any evidence. So Manu says it is possible for a defendant to come to court and say, Sampratipatti, I admit the claim. Second defense, Pratyavasbandhanam, confession and avoidance. This is also called Karanottara. We will not go into all those details. Then he may say Mityokti or complete denial of plaintiff's claim. And number 4, Prajnaya or prior adjudication, which is what is now provided by section 89 CPC. Manu also talks about a principle which is similar to our res judicata today. Today under the Civil Procedure Code, we say that if what is in issue before court in a case today has already been an issue in a previously decided case, then this is barred by the principle called res judicata. Manu has developed something similar to that, and he calls it Vada Sankraman. Manu also talks about joinder of causes of action, misjoinder of causes of action, limitation. He says limitation is what is called bhukti. A stale claim cannot be adjudicated in a court. So our Dharma Shastras have codified lot of such things. Now, after having seen this, a broad outline of what these Dharma Shastras are, I should also tell you that all these Dharma Shastras lay down what kind of judges could be appointed to courts. It is very interesting to note that these Dharma Shastras segregate those appointed as judges to deal with criminal cases and those appointed to deal with civil cases. These Smritis also talk about judges sitting in a combination of 2 or 3, which means there was a possibility of division benches, there was a possibility of full benches, and there was a possibility of constitution benches to hear certain cases. What are the qualifications of judges? What are the code of ethics to be followed by judges are all very clearly delineated in most of these Dharma Shastras. It may require some more elaboration. We'll keep it reserved for another day. Having covered this Dharma Shastras, given a broad outline of this, what these Dharma Shastras are, now let us have a brief introduction to what this Artha Shastra is. As I told you, there are 4 goals of human life: Dharma, Artha, Kama and Moksha. Artha deals with means of life. Therefore, Artha Shastra is mostly on the economics. All of you know Kautilya wrote this Artha Shastra, and many people place it in different points of time, but at least historians agree that he must have lived between 350 BC to 150 AD. So it's about, certainly all historians, even those who do not accept the greatness of our country, agree that Artha Shastra should be 2000 years old. Let us start from that point itself. Arthashastra, interestingly, speaks about three different types of judicial officers. First type of judicial officers were called dharmasthas, judges. Second set of judicial officers were called pradeshtir, that is magistrates dealing with criminal cases. And the third set of judges were called samahartar or chancellor. A code of conduct for judges is laid down by Kautilya in his Arthashastra, Book 4, Chapter 9, from verses 13 to 16. What is the code of conduct laid down by Kautilya in his Arthashastra? I will now read out the translation. A judge shall not, this is what Arthashastra says 2000 years ago. A judge shall not threaten, intimidate, drive away, or unjustly silence any litigant. First rule. Second, a judge shall not abuse any person coming before the court. Number 3, a judge shall not fail to put relevant and necessary questions or ask unnecessary and irrelevant ones. This is traceable to a particular provision in the Indian Evidence Act today, which came only in 1872. A judge shall not leave out of consideration answers relevant to his own questions. So it goes on and on. Chapter 7 of Book 4 of Kautilya's Arthashastra deals with post-mortem examination. Can you believe the kind of rules that Kautilya had come up with for post-mortem examination? Kautilya states that the magistrate shall conduct a post-mortem on any case of sudden unnatural death after smearing the body with oil. What is the purpose of smearing the body with oil? Once you smear a dead body with oil, any bruises, swellings, and external injuries on the body will be very clearly visible. This is how he explains it. And he says, examination on the cause of death should be conducted even in cases where a person has committed suicide. So this is not something which we have borrowed from the English tradition. Kautilya identifies causes of death into 3. Number 1, stoppage of breath by strangulation, hanging, asphyxiation or drowning. Number 2, death by physical injury by beating or throwing from a height. And number 3, by poisoning. Kautilya also talks about forensic evidence for establishing the cause of death. Just see how he deals with forensic evidence. He says, if a person has been strangulated to death, Kautilya says, urine and fecus would have been thrown out of the body. This is true. And the skin of the abdomen would have been inflated with air. Hands and feet would have swollen, eyes open, and there will be marks on the throat. So how do you identify the cause of death by strangulation? By these factors, he says. Then he says, if in case a death is, in fact, he also says that if a death is caused by narcotic drugs, then the clothes would have been strewn about, body spread-eagled, excessive vomiting and purging will denote that a person has died due to narcotic drugs. This is what Kautilya says. What we have learnt is probably narcotic drugs were available even in Kautilya's time. Otherwise, this could not have come. He says, in case of death due to poisoning, the undigested parts of the meal should be tested by feeding it to the birds. If these parts when thrown to fire, produce a crackling sound and become multicolored, then poisoning is proved, according to Kautilya. Even today, forensic science acknowledges that if a undigested poisonous substance taken from your stomach is thrown into the fire, it produces crackling sound and the color of the fire becomes different. So that was identified by Kautilya 2000 years ago. Where is the place for Nyaya Shastra? Now we have seen Dharma Shastras, we have seen Artha Shastra. Where is the place for Nyaya Shastra? It is not enough for people to know what Dharma is, what Artha is. Because there are situations in life where two dharmas will be in conflict with each other. Take the case of Sibi Chakravarti. How many of you have heard the story of Sibi Chakravarti? Have you heard the story of Sibi? Sibi was a king. I'll tell you the story. Sibi was a king. One day, he was a man of lot of compassion. One day, a huge vulture was chasing a pigeon because pigeon happened to be the prey for the vulture. That pigeon flew and took shelter on the lap of King Sibi. Sibi belonged to the Surya Vansh. He was an ancestor of King Rama, Lord Ram. So this pigeon took shelter on the lap of Sibi, king. The vulture came chasing. King said, "No, this pigeon has taken shelter. I cannot give it to you." Then that vulture asks a question to Sibi. "O king, you know all the dharmas. A vulture is not a vegetarian. I am fundamentally a non-vegetarian. I prey only on other animals. It is my dharma to kill another animal so long as it is my food. By giving shelter to the pigeon, you are upholding one dharma, namely the dharma of compassion to the pigeon. But by depriving me of my food, you are indirectly starving me to death. You are killing another dharma. Therefore, how do you match these two situations? Which is the dharma that you should follow in such a situation? You give refuge to a prey, but you starve the predator to death. Which is dharma? Sibi Chakravarti comes up with a very strange solution to the problem. He says, I have shown compassion to the pigeon, I cannot hand it over to you. Therefore, I uphold my dharma of compassion. But at the same time, I will not starve you to death. I offer my own flesh to you to eat so that you don't starve to death. So he cuts the flesh out of his thigh and offers it to the vulture. And then the vulture takes the form of Lord Dharmaraja and says that I came here to put to test your knowledge and practice of dharma. So when two sets of dharmas compete with each other, how do you resolve? This question led to the creation of Nyaya Shastras. You resolve this conflict by logic and reasoning. This logic and reasoning constitute the bedrock of Nyaya Shastra. This Nyaya Shastra, the oldest name given to Nyaya Shastra, today we only know that this is Nyaya Shastra, but the oldest name given to Nyaya Shastra is Anvikshiki. It's called Anvikshiki. Kautilya, in his Arthashastra, interestingly says, Anvikshiki is a science which a king should compulsorily learn at a very young age. The first chapter of Arthashastra itself is Vinayadhikarika, concerning education. According to Kautilya, the object of Arthashastra is to groom a prince, the son of the king, to become the king later. So a king should be imparted 4 types of knowledge according to Kautilya. These 4 types of knowledge are Anvikshiki, which is Nyaya Shastra, then Vedatrayi, 3 Vedas, then Varta, and Dandaniti. Dandaniti comes later, but Anvikshiki Nyaya Shastra comes first. So Nyaya Shastra was developed as a science of logic and reasoning to help people resolve the conflict between 2 dharmas. There are a lot of stories in our mythology as to how what such conflicts have thrown up in life. For instance, when Draupadi was disrobed, Draupadi was brought to the Duryodhana's Sabha, she asks a question whether Dharmaputra lost himself first before losing her, or whether he betted upon Draupadi before he lost himself. This question assumed significance due to the simple fact that if a person loses himself first, he lost his right to property. When he lost his right to property, what was his right to bet on Draupadi was the question posed by her. Even a person so learned in the Shastras like Bhishma tells the audience that Dharma is of such a nuance, Dharma is so nuanced that I am not able to find an answer to this question. Therefore, to give you an overall picture, our culture places 4 goals of human life: Dharma, Artha, Kama and Moksha. To enable people to know what is Dharma, 14 branches of knowledge were developed, of which Dharma Shastras is one. 18 rishis codified these Dharma Shastras called Smritis, and those Smritis were named after these sages. In order to understand how they operate, Kautilya brought this Arthashastra. He put into practice the procedural law, and then the Nyaya Shastra was used to resolve the conflict between 2 sets of dharmas.
Namaste sir, I'm Chandrapiyush Bajpayee, and interestingly the name of this talk is Inclusion of Ancient Indian Philosophy in Jurisprudence. Now my question is it practical and possible to completely sort of replace the Latin underpinnings of current Indian laws by our ancient philosophies?
Actually, the object, in my own understanding and in my view, is not really to replace the existing laws. The purpose of introducing you to all this is that we have developed a kind of reticence, thinking that but for the Englishmen, we would never have had a good jurisprudence, we would have never had a good system of administration of justice. Our objective is to bust this myth and show that we had a far superior system of administration of justice suited to the times of those days. And many of the principles that we now have are not principles which have evolved from the Englishmen, but we have had their roots in the past. That's our objective.
Should we not replace it entirely?
Replacing it entirely may be a little difficult. I will tell you how. Why it will be difficult, I will tell you. See, for instance, section 107 and 108 of the Evidence Act speak about presumption of death. Okay? If a person is not heard of for 7 years, then he is presumed to be dead. This is a procedural law under the law of evidence, right? Interestingly, I had an occasion to do some research on how the 7 years came into existence. Why 7 years? It could be 10 years, 15 years. What is this 7 years? When I did research, I found out that in England, this presumption of death, if a person is not heard of for 7 years, was developed for the first time under the Bigamy Act of 1602. Why? Englishmen, those days, the 15th century, 16th century, they traveled all over the world in ships to conquer other countries. There were no postal department, mobile phones, WhatsApp communications. There was no way they could communicate with their kith and kin. So their family members did not know whether they had died, they will come back, not come back, etc. A peculiar situation arose where when some of them came back, they saw that their wives were living with other men. So complaints of bigamy were made. Then the British Parliament thought that what would a family do? The family cannot live in penury, waiting for this man to come without knowing whether he will come, whether in the ship got destroyed, ship sank, he died, etc. Therefore, the rule that there is presumption of death, there could be presumption of death, was developed as a defense to an action for bigamy. So 1602 is where you trace this law. Now let us come to whether we will be able to replace it with Manusmriti or Yajnavalkya Smriti. Yajnavalkya Smriti and Manusmriti 2000, 3000, 5000 years ago talk about this presumption of death. So it may appear to be immediately feasible for you to adopt it now. But you know what it says? Yajnavalkya Smriti says, in fact, what was prescribed as a procedural law in the Evidence Act is actually made a substantive law in all these Smritis. You know how? It says, if a Brahmin is not heard of for 4 years, and if he has not left a child, his wife can take another man. If a Kshatriya is not heard of, his wife should wait for 3 years. So the rules were prescribed in these Dharmashastras depending upon the Varnashrama to which you belong. How do you adopt it now? That is where the difficulty comes.
Sir, you mentioned about Manusmriti. Many people often argues that Manusmriti is against, the principles of Manusmriti is against women. In contrast, there is a principle of Manusmriti in chapter number 3, verse number 56, where it is written that Yat Naryastu Pujante Ramante Tatra Devta. It means जहां नारी की पूजा होती है वहां देवता भी वास करते हैं. सो माय क्वेश्चन इज दैट कि क्या ये पैराडॉक्स सच में है मनुस्मृति में या ये लोगों के द्वारा सिर्फ मिसगाइड किया जाता है? आपके क्या व्यूज है इस पे?
Actually, you must know that the laws reflected the social order prevailing at that time. Manu definitely contains, see, we must be very open. Manu definitely contains some portions where women ought to be, it says women ought to be treated as properties of the husband. A woman is dependent till her marriage upon her parents, then after her marriage upon her husband, and after a particular age she is dependent upon her son, is what Manu says. We cannot shy away from this fact. But unfortunately what has happened is, it is only those portions of Manu which are quoted by people who attack Manu. But as I now said, after 4 years, after waiting for 4 years for the husband to return, if the husband does not return, a lady can take another man, is what Manu says, which means Manu has recognized the right of women to remarry. This we don't talk. Those people attack Manu for whatever he has said, which is not palatable with today's generation. But we don't tell them that this is also what Manu has said, because we don't read. All of you should accept one fact. Persons who attack something read it much better than persons who support something.